Good morning. Please take your seats. Is that sufficient? They're getting to it. Just a few logistical notes before we start with the program. Very much appreciate having you here. My name is Dave Lawrence. I'm chief of the competition policy section here at the Antitrust Division. We'll begin the morning with remarks from, we're fortunate to have two distinguished opening remarks, AAG DELRAHIM and Commissioner Wilson, both of whom have been big advocates for this process between our agencies. And I think if you read some of their writings, they're both thought leaders in this space. So I think we have a good start to the morning. Thank you. MAKAN?
Well, thanks, David. Thanks for many of you who are here. We obviously had a tough decision as we consider every event these days that has a gathering of a number of people. This will be, I believe this is streamed at least, and people will be able to participate. We're wishing the best for anybody who is at risk of the current virus and the best for the future as we tackle this, not only for everybody's health, but also for the broader global economy. I also have to commend Dave and Karina and the team, both at DOJ and FTC, for the very clever logo for the guidelines that they put together. Us lawyers, and certainly not antitrust lawyers, are not known for our creativity, but we somehow, every now and then, can amaze ourselves with a creation that our great, talented staff can come up with. Well, good morning and welcome to the Robert Kennedy Main Justice Building. I'm pleased to have the great privilege to open today's workshop on the proposed vertical merger guidelines released jointly by both the Department of Justice's Antitrust Division and the Federal Trade Commission. This workshop is the first of two that we, together with the Commission, will hold on these proposed guidelines. I want to thank the Federal Trade Commission for working so cooperatively with us in this process. In particular, I appreciate the ongoing work over the past year and going back even further of the staff from the Office of Policy Planning, the Bureau of Economics, the Bureau of Competition, of course, the Commission led by Chairman Simons, and this particular project with the leadership of Commissioner Christine Wilson. I want to recognize and welcome her to the division, and she is here on behalf of the FTC and will be offering some remarks immediately right after mine, as David said. Although the Department of Justice issued its 1984 non-horizontal merger guidelines unilaterally, we are committed to working with the FTC in finalizing these new vertical merger guidelines, and we hope to issue the final joint version soon. I also want to thank our panelists for the participation in this workshop. We have a distinguished group representing the broad engagement we have had and continue to have in this process. I'm pleased to welcome back many of the division alumni, as well as a number of our former FTC colleagues who are here. Our panels will also include luminaries from the private bar, academia, and the public interest sector, without whom the product would not be where it is today, nor would it be as good as it is today. Finally, I want to thank everybody who submitted public comments. We received 70 comments longer than a page from a diverse array of interested groups and individuals, including by our panelists here today. I want to single out comments from a group of 26 state attorneys general, which were thoughtful, productive, and collegial. I also want to thank the FCC's Office of Economics and Analytics for its comment supporting our proposed guidelines and offering some helpful insights based on their expertise with vertical mergers. The comments span the range of views on this important topic. Some comments suggested specific line edits to the proposed guidelines, while others offered more theoretical thoughts on vertical merger enforcement. Many of us saw 2 years ago, we had hundreds of experts in vertical mergers on television all over the place. Some comments criticize the proposed guidelines for suggesting gross over-enforcement against vertical mergers. They advocate for what amounts to changing the law to favor vertical mergers as per se legal. Other comments criticize the proposed guidelines for suggesting gross under-enforcement against vertical mergers, and they advocate what amounts to changing the law to disfavor any such deals. We, of course, value a broader debate about the antitrust laws and hope that today's workshop will facilitate this dialogue. It's important that we understand the differences of opinion in the policy and the business community as we seek to produce the best possible version of the final vertical merger guidelines. That version, though, will reflect what the law actually is, as opposed to what some may think it should be. Of course, should there be a need to change the law, there's another branch of the government that's appropriately empowered by our Constitution, not us. All merger guidelines stand in the shadow of the great Bill Baxter, former professor at Stanford and a predecessor of mine as the Assistant Attorney General. His 1982 horizontal merger guidelines brought economic rigor to the practice and revolutionized antitrust enforcement. He said that, quote, "Writing guidelines is hard work. Tough to disagree." He also said that, quote, "There's a very real element of fact in the guidelines. In that sense, it is a fairly careful description of a way of going about thinking about mergers, a thought process about mergers, and our own intuitive reactions to a series of mergers that we saw over a period of time." Professor Baxter's description applies equally to these proposed vertical merger guidelines. Guidelines should first and foremost provide transparency into what we actually do at the agencies. The final guidelines simply will aim to provide transparency into our investigative practices as they exist today and have in recent years based on the underlying law. With transparency comes predictability. And the great Robert Jackson captured this goal well in a speech he gave in 1937. In that speech, Jackson characterized the previous 40 years of antitrust enforcement as alternating between, quote, being aggressively vague and passively vague, end quote. He recognized that, quote, every antitrust problem is economic as well as legal. And he sought to articulate a standard for antitrust law enforcement, quote, intelligible both to those expected to comply with it and to those expected to enforce it. Again, I stand with the great Robert Jackson on that proposition. The guidelines are fundamentally descriptive, not prescriptive. We are trying to get it right, and these guidelines provide insight for the business community and the public into the kinds of evidence we look for on a case-by-case basis. They will give greater predictability and intelligibility to business, the bar, and to enforcers. When it comes to antitrust enforcement, careful analysis of particular cases matters tremendously. That is always true, but I think it's especially true for vertical mergers. Vertical mergers can be pro-competitive, for example, by eliminating double marginalization. Over-enforcement risks blocking deals that could benefit consumers. In fact, many vertical mergers are either pro-competitive or competitively neutral. While many vertical mergers may be competitively beneficial or neutral, the wrong vertical merger can create and entrench monopolists. The risk can be heightened in digital markets where a common refrain is that vertically integrated platforms have access to data that potential rivals need to compete. If the data plays an important role in designing products or services for the consumer, and it is available only to a platform because the service acquired it through a merger, then it might create the ability to raise rivals' costs downstream. Importantly, as we think about the potential for a vertically integrated company to harm its rivals or gain a competitive advantage, we must keep in mind that there's a different standard for mergers than for non-merger conduct. Section 7 of the Clayton Act governs anti-competitive acquisitions. Outside of a merger context, cases involving vertical agreements or attempts by a vertically integrated firm to harm upstream or downstream rivals would have to be challenged under Section 1 or 2 of the Sherman Act. The D.C. Circuit opinion in AT&T was very clear on this point, and I consider it a significant development of our jurisprudence. The court applied Section 7 to that vertical merger the same way it has for horizontal mergers. It said that Section 7, quote, applies a much more stringent test than does the rule of reason analysis under Section 1 of the Sherman Act. There are important reasons for that approach. While Sections 1 and 2 are inherently backward-looking, Section 7 looks to the future. It asks whether, quote, the effect of an acquisition may be substantially lessen competition or tend to create a monopoly. If the answer is yes, then the merger is illegal. The Section 7 standard allows a division to act before a problem arises, as Congress intended. Its purpose is to keep the structure of the market competitive so that market forces can play out to the benefit of consumers without the day-to-day policing of whether the players in the market are behaving anti-competitively. For this reason, merger review requires a division to address circumstances that would not be illegal under Section 1 or 2. For example, under Section 7, a merger to monopoly would be illegal. Outside of the merger context, however, the Antitrust Division does not seek to break up a monopoly that has been lawfully acquired and maintained and is not engaging in exclusionary or predatory conduct. These proposed guidelines are an important part of helping us get the right answer on these vertical mergers. They reflect current case law and economic thinking about vertical mergers, as well as current department and FTC practice in investigating vertical mergers. Until this past January, the only formal statement of enforcement priorities on vertical merger were the 1984 non-horizontal guidelines. 35 years ago, the 1984 guidelines represented the department's best effort to provide guidance on how it evaluated vertical mergers. As one scholar has recognized, however, they are, quote, now woefully out of date and do not reflect current economic thinking about vertical mergers, nor current agency practice. We are not, of course, writing on a blank slate. While the 84 non-horizontal guidelines may be out of date, and while AT&T may have been the first litigated vertical merger challenge since the 70s, both the Department of Justice and the Federal Trade Commission have enforced the antitrust laws consistently against anti-competitive vertical mergers. In fact, Professor SALLET has counted 58 vertical enforcement actions by the Department and the Commission between 1994 and 2018. I'm glad that Professor SALLET is here today to share some of his insights on these proposed guidelines. We always learn when he speaks. We're already well underway in synthesizing the comments we've received, and this public workshop today should help us further hone the final guidelines. I look forward to hearing further from the public and to issuing soon, together with our friends and colleagues at the FTC, a final document that benefits from those views. Thank you, and I look forward to the comment by our panelists today. Commissioner Wilson.
Good morning, everyone. Is Professor SALLET here this morning? I don't see him. Maybe he'll arrive in a bit. I'll be referencing him. I wanted to be able to look at him when I did. So I am delighted to be here this morning with my esteemed colleagues from the Antitrust Division and with such a distinguished collection of participants. As did AAG DELRAHIM, I commend both the FTC and the DOJ for all of their hard work in preparing the draft vertical merger guidelines. It is so clear that many hours and much interagency collaboration went into the current document. This collaboration is incredibly important. When I graduated from law school, I worked with Jim Rill, former AAG for the Antitrust Division, when I was just a young associate. And Jim taught me all about international competition law. I worked with him on the International Competition Policy Advisory Committee report, and he opened up an entire world for me that I have spent a lot of time and effort on over the course of many years. And it has become clear to me over the course of my work in the international arena that U.S. antitrust enforcement is strongest. And U.S. antitrust agency leadership is at its best when the two agencies speak with one voice. It assists businesses and stakeholders domestically, but it also assists ensuring best practices abroad. And so it is my fervent hope that the collaboration, the very constructive collaboration between the two agencies can continue through issuance of a final joint work product. I also want to thank all of the commenters who have really poured a lot of time and effort into giving us such thoughtful comments. I read, I will admit, not all of them, but many of them, and those comments helped me refine my own thinking about the draft that we have and also about vertical merger guidelines and principles in the abstract. Let me just take one example. Another early mentor of mine, Professor Steve SALLET. He co-authored not only two different sets of comments, but an entire alternative set of guidelines because he is just a dedicated overachiever. But he's not alone, obviously. The work that has been done by so many eminent legal and economic scholars like Steve speaks to the importance of getting the vertical merger guidelines and vertical merger enforcement right. So thank you to everyone who commented. Your insights have been greatly appreciated. Today, I'd like to highlight some themes and questions that emerged from the public comments that I found particularly compelling. Of course, before I begin, I must offer the usual disclaimer that I am speaking for myself, not for my colleagues down the street or for anyone else at the Federal Trade Commission. Let me just begin by stepping back and asking, why new vertical merger guidelines now? There are a number of commentators who've written about the purpose of guidelines, and MAKAN shared with us some of those. Paul Eady and Greg Worden have written particularly extensively on this topic, and they offer at least 3 reasons for new guidelines. First, the agencies may use guidelines as a way to summarize the law, just as ALI issues restatements of law for contracts, property, and other topics. Second, guidelines may disclose and formalize an approach the agencies have heretofore used informally. And third, the agency may use guidelines to advance new analytic techniques. I think that vertical modeling is still perhaps roughly an equal mix of art and science, and so I would submit to you that we should not, and we have not, use these guidelines to advance new analytic techniques. I do think that these guidelines are going to be most effective, most constructive, if they distill and codify and share with the antitrust community the way we actually conduct our analysis of vertical mergers behind closed doors. And so it is through that lens that I'll be formulating some of my comments. So one comment specifically asked if the draft guidelines are intended to announce a shift in policy toward challenging more vertical mergers. My own view is that any new vertical merger guidelines, as I said, should codify existing enforcement practices. Now, to be sure, our understanding of vertical mergers has changed since the 1984 guidelines were issued, And at the FTC's hearings on competition and consumer protection in the 21st century, participants in our panels on vertical mergers agreed essentially unanimously that the 84 guidelines are woefully outdated. But I am not aware of any legal or empirical economic scholarship that would merit an across-the-board increase in vertical merger enforcement above current levels. Second, should EDM be treated symmetrically with raising rivals' cost theories of harm? Some commenters call for the elimination of double marginalization to be treated like a cost-saving efficiency. Others call for the discussion of EDM to be incorporated into the unilateral effects section, emphasizing the interdependence between EDM and potential harms. I found compelling the perspective of those commenters who assert that EDM arises from the same economic incentives as the leading vertical theory of harm, raising rivals' costs. As you know, RRC occurs when a merged firm increases price to other downstream firms to drive sales to itself, and EDM occurs when the merged firm sells to itself at cost, resulting in lower prices to its consumers. Both EDM and RRC result from changed economic incentives generated by the merger, as opposed to cost-saving efficiencies that might be generated by, say, the combination of complementary productive assets. In other words, EDM occurs even in the absence of cost-saving efficiencies. Several comments pointed to recent economic papers emphasizing that RRC effects and EDM effects are correlated in size across a variety of market shares and concentration levels. These commenters provided compelling arguments that EDM is actually a determinant of the size of RRC. As one comment points out, a large EDM effect can even cause the merged firm to lower the price it charges to other downstream firms. Consequently, in my view, RRC analysis must simultaneously and symmetrically address EDM. Evidence, whether qualitative or quantitative, that a merger is likely to generate large RRC effects is unavailing without a concurrent EDM analysis. The vertical analysis that I've seen from FTC staff and outside experts does reflect a symmetric approach to EDM and RRC. And again, since vertical guidelines are only useful to the extent they codify existing practices, it is important, I believe, that any guidelines treat EDM and RRC symmetrically. Let me switch to another question. Do agencies or parties bear the burden of demonstrating EDM? The draft guidelines state the agencies generally rely on the parties to identify and demonstrate whether and how merger eliminates double marginalization. This sentence generated many comments about what this reliance might look like. Again, to rely on my experience with FTC staff, we rely on parties' information to conduct competitive effect analysis. So in a horizontal merger, parties' business documents or transaction data obtained via second request may inform assessments of the degree of substitutability between merging firms. In a vertical context, assessments of both RRC and EDM will depend in part on information provided by the parties. For example, information on pre-merger markups would inform analysis of the magnitude of EDM and RRC. Under a symmetric approach to RRC and EDM, requiring parties to, quote, demonstrate a merger's EDM would amount to demanding a full competitive effects analysis from merging parties. In my view, therefore, a literal interpretation of this language would lead to an unfortunate approach. My view is that for any effects analysis, merging parties have a burden of production, but agencies have the burden of proof. Given the many comments relating to the burden of EDM, it may be that the language in the draft guidelines could stand to be clarified. Fourth, when is EDM merger specific? Regardless of how one allocates the burden of demonstrating EDM, many commenters pointed out that meeting the burden depends on the standard for merger specificity of EDM. At issue is the possibility that two unintegrated firms can achieve the same benefits of EDM via contract. For example, such a contract could obligate the upstream firm to sell its product at cost in exchange for an upfront payment from the downstream firm. I find compelling the comments stating that if pre-merger contracting eliminates all or nearly all of one margin, a vertical merger is unlikely to result in pro-competitive EDM. But I would not have our competitive effects analysis hinge on the possibility of contracting outside a merger. So writing guidelines is hard, as Bill Baxter said, but so is contracting. As one comment observes, mergers, quote, solve coordination problems that are solved less well or not at all by contracts. And another states, a merger is the only realistic and practical way to eliminate double marginalization. It is simply not realistic that arm's-length parties could sufficiently align their incentives to eliminate double marginalization. Another mentor of mine, there are four, I'm probably not going to rely on Tim Muris today, but the third is Roger Blair, who's a professor at the University of Florida. He spent about 12 years of his career focusing on the effects of vertical integration through contract and through merger. And his work teaches us that factors like demand uncertainty, risk aversion, information asymmetries, and transaction costs make efficient contracting incredibly difficult, maybe even impossible. So for me, the relevant question would focus our inquiry on whether the firms did achieve efficient contracting before merging, not on whether they could. In my view, only in the former case should we alter our competitive effects analysis. Suppose, for the sake of argument, the agencies dismissed EDM when they believed parties could contract more efficiently absent merging. I think this approach would raise several questions. For example, how do we square a finding that such contracting would be profitable with the plain fact that the parties were unable to implement efficient contracts in the absence of the merger? Why would parties incur the expense, time, and uncertainty of HSR review if the same benefits were available to them through contract? How are the agencies to distinguish those firms that could realize EDM via contract from those who could not? Would the agencies treat RRC effects, which could be achieved by contract, symmetrically? As a practical matter, the FTC routinely collects data and documents relating to firms' supply contracts in the course of its antitrust investigations. I can't recall an instance where a firm managed to fully eliminate double marginalization by contract. The most likely explanation for not observing EDM among integrated firms in the wild is that contracting costs preclude full EDM. Of course, we do see various forms of nonlinear pricing, like two-part tariffs in the real world. But I agree with the comment noting the mere existence of a contract capable of mitigating EDM does not tell us about its efficacy compared to vertical integration. In summary, I think it's completely appropriate to assess the nature of pre-merger contracting as part of a competitive effects analysis, but I would base competitive effects analysis only on what the market looks like, not on what the agencies think it should look like. Fifth, should we use a safe harbor or a 2020 screen for mergers that are likely benign? I think it's interesting there is perhaps no other aspect of the guidelines that provoked more comments than this topic, that the agencies are unlikely to challenge a merger in which both upstream and downstream shares are below 20%. Some comments worry the screen may miss problematic mergers. Some worry the screen will inappropriately develop into a structural presumption. Few, if any, comments defended the 2020 screen. In fact, an array of comments expressed highly negative views, calling it arbitrary and unprincipled and ineffective and useless, and stating that it doesn't provide much certainty and has no basis in the social science literature. So I hear these concerns loud and clear. My view is that a screen would have one purpose: to rule out harm at an early stage before staff resources are consumed. Finite resources mean we need to draw the line for case selection somewhere, and smaller firms in less concentrated markets are, in general, more likely to fall below the line. I fully agree with commenters that neither law nor economics support an inference of illegality on the sole basis of shares, particularly for vertical mergers. Stepping back, I think our instinct to use market shares to analyze vertical mergers likely derives from well-honed techniques for horizontal merger analysis, ranging from our humble delta HHIs to state-of-the-art merger simulation models. And we use shares heavily in those approaches. But we should use caution in applying horizontal logic to vertical mergers. If horizontal merger analysis weighs anti-competitive effects against cost-saving efficiencies, vertical analysis adds a third factor, EDM, a pro-competitive effect. As I described earlier, pro-competitive EDM and anti-competitive harm tend to increase or decrease in concert across different levels of market concentration, according to new economic analysis. And that means we can't rely on concentration screens in the vertical merger context as we do with horizontal ones. So high upstream and downstream shares bring us closer to the textbook case of successive monopolies, often used as an illustration of merger with EDM, but no adverse effects. And so I think Professor Sallep's alternate guidelines that he submitted perhaps diverge from these principles, and it's not his fault that I've become wayward after leaving his classes. The correlations between EDM and RRC imply that mergers are more likely to result in anti-competitive RRC are also more likely to result in pro-competitive EDM. I think, having looked at all of the comments, this share threshold is clearly causing more consternation than clarity, and so I think we're going to need to think very carefully about how to address the concerns expressed in the comments. For the final topic, I'd like to highlight the relative likelihood of harm from vertical transactions. Economists have conducted a number of retrospective studies of vertical mergers. Most suggest that consumers benefit. For example, LaFontaine and Slade found in a 2007 survey that efficiency considerations overwhelm anti-competitive motives in most contexts. A 2005 survey by 4 FTC economists found similar results, and so did a 2018 survey by economists at the Global Antitrust Institute. I would love to see more vertical merger retrospectives regardless of the result. I think we should be doing those, and I would love assistance from the bar and from academics in doing those. And if we are missing harmful vertical mergers, I would like to know that. But given the current state of the economic and empirical literature, I agree with the comment that observed a, quote, deafening silence concerning the agency's general attitude toward vertical mergers. The 84 guidelines state that vertical mergers are less likely to be problematic than horizontal mergers, and so do the European Commission's 2008 guidelines. I don't believe that anything has changed between when those guidelines were issued and now that would make a disclaimer of this type inappropriate for our current draft guidelines. Indeed, the vast weight of economic scholarship continues to find that most vertical mergers benefit consumers, and the frequency of agency scrutiny of vertical mergers remains roughly constant. One comment observes the agencies have only conducted detailed investigations of at most 2 to 3 vertical mergers per year. I think these statistics may diverge slightly from Sallep's, but this comment found 1 per year resulting in a remedy. Now, granted, during my tenure at the Commission, we're above that run rate, but we are reacting to the mergers that are notified to us. Overall, we see a much lower remedy and intervention approach for vertical mergers. And so I think it would be helpful to include this kind of relative language in the draft guidelines that we have. Doing so would provide useful guidance to businesses about how the agencies view vertical enforcement and best reflect what we can learn from the empirical economic literature. And on a related note, one comment picks up on the fact that Section 8 of the draft guidelines states that vertical mergers have the potential to create cognizable efficiencies. Specifically, the comment notes this language appears to signal a retreat from the 2010 horizontal merger guidelines, which state a primary benefit of mergers to the economy is their potential to generate significant efficiencies and thus enhance the merged firm's ability and incentive to compete. To avoid creating the false impression that the agencies have changed their approach to efficiencies from 2010, I think the draft guidelines should more clearly state the ways in which vertical mergers can generate efficiencies. And so with that, let me get out of your way so that you can continue on with all of the distinguished participants who are here today. Thank you once again to everyone who submitted such extensive and thoughtful comments. I found them incredibly useful. It's one of the things I love about being in the antitrust bar. We do have such a robust dialogue in this community about what the right approach is. And so thank you again for those comments. I do believe that the excellent comments we've received chart a path forward for the vertical guidelines. And as I said at the outset, I think it is incredibly important for FTC and DOJ to speak with one voice in offering clear guidance on vertical enforcement practices. Thank you, and enjoy the rest of the day.
So we'll go right into our first panel, moderated by David Shaw and Heather Johnson from DOJ and FTC respectively, and they'll introduce our panelists.
Well, good morning, and welcome to the first of two workshops that the Department of Justice and the FTC are hosting on the proposed vertical merger guidelines. My name is David Shaw, and I serve as counsel to the Assistant Attorney General here at the Antitrust Division. And together with Heather Johnson from the FTC, I'm pleased to help moderate our first panel featuring perspectives from former enforcers and current practitioners. We have a very distinguished panel. We also have a very sophisticated audience. I see many familiar faces, and I know we have practitioners, academics, policymakers, and both current and former enforcers. And I trust we'll all be edified by the coming discussion. Just a brief note on format. Heather and I will introduce our panelists and then ask pretty broad questions and allow the panelists to discuss and debate some of the important issues raised by the vertical merger guidelines, the draft vertical merger guidelines, including many of which Commissioner Wilson just previewed. And I would just say crosstalk is encouraged. So with that, let me hand it over to Heather.
Hi, my name is Heather Johnson. I'm Senior Counsel to the Director of the Bureau of Competition at the FTC. I want to thank David and everyone at the DOJ for allowing us to participate in this and for the collaborative, collegial process that we've had on this workshop and also with the vertical merger guidelines more generally. I have the true honor to introduce some of our distinguished panelists, starting with Renata Hesse. She is co-head of Sullivan & Cromwell's Antitrust Group. Her practice focuses on representing some of the world's biggest companies on a range of high-stakes antitrust matters, including antitrust counseling, cartels, and merger clearance. Ms. Hesse joined Sullivan & Cromwell in 2017 following a distinguished career in government, including serving as the acting AAG for the Antitrust Division here at the DOJ. And she served that division for more than 15 years. Jonathan Jacobson, to her left, is an antitrust partner at Wilson Sonsini. Jonathan served as chair of the ABA's antitrust section for 2017 and 2018, and he previously served in numerous antitrust section leadership positions, including editorial chair of antitrust law developments. He was appointed by Congress to serve on the Antitrust Modernization Commission, and he has served as lead counsel in major cases for some of the world's biggest companies. He's often appeared at DOJ and FTC workshops, just like this one, and has numerous publications, including recently and relevantly, Vertical Mergers, Is It Time to Move the Ball?
Our next panelist is Bob MAJURE, who, as the resident economist on the panel, is appropriately seated right in the center, since economics is so central to our analysis. Bob is currently the vice president of Cornerstone Research, but prior to that, he was the director of economics for the Antitrust Division, where he worked for almost 25 years. And in that time, he worked on numerous vertical mergers, including CVS Aetna, AT&T Time Warner, Comcast NBCU, Monsanto Delta, and Pine Land Company. He was also on the committee responsible for drafting the 2010 horizontal merger guidelines. Sitting next to Bob is Jonathan SALLET, who served as a Deputy Assistant Attorney General in the Antitrust Division during the Obama administration and is currently Senior Fellow at the Benton Institute for Broadband and Society. He also assists the Attorney General of the state of Colorado on antitrust issues as a Special Assistant Attorney General. And then I'll let Heather introduce our last.
And last but not least is Craig WALDMAN, who co-chairs Jones Day's global antitrust practice. He has practiced law for more than 25 years, representing companies in antitrust investigations, private litigations, and counseling on how to manage antitrust risks. Craig's private practice work has spanned all areas of antitrust. He previously served for 3 years at the FTC, during which time he was involved in high-profile investigations, including Rite Aid Revco, Lockheed Martin Marietta, and Glaxo Wellcome. Craig frequently presents on antitrust issues, serves in ABA antitrust leadership, and has served as an adjunct professor at both Berkeley and Hastings law schools. We have 100 years or more of antitrust experience on the stage, so without further ado, let's start mining it.
Well, great. One programming note, we will be taking questions from the audience on 3x5 cards that should be available, and if you need one, raise your hand and someone will get it to you. And if you have a question, again, you can hand one of these cards to Mac. Mac, are you there? Could you wave your hand? Mac, standing right there. So that's how we'll facilitate full audience participation. So, John Jacobson, first question for you. You served on the Antitrust Modernization Commission, and in 2007, in its report, the AMC recommended that the agency should update the merger guidelines to include an explanation of how the agencies evaluate non-horizontal mergers. To get us started, can you briefly explain your views on the purpose of vertical merger guidelines and why you support the idea of the agencies providing guidance on these topics?
So when we made that recommendation, it was 2007. We had just received the commentary on the horizontal merger guidelines from the Justice Department and the FTC, which was a remarkably useful document. And although the 92 guidelines were getting a little gray, long in the tooth, not gray in the tooth, it was time to focus on, can't we do something about vertical? Everyone knew at that point that the 84 guidelines discussion of non-horizontal was out of date. So it wasn't all that difficult, and it certainly wasn't particularly sophisticated to say, well, you have these really neat 1992 guidelines, you have this really cool horizontal merger guideline commentary. Why can't you give us some guidance on vertical mergers? It was not a lot more specific than that, and candidly, if we had gotten into the specifics, we would not have had such a unanimous recommendation. But it does raise the question, what are the purposes for guidelines? And I know we're going to get into that next. Is it to tell us what the agencies are doing? Is it to mold the law? Is it to provide guidance to the business community on what can and cannot be done? Those are a number of issues, and I think we'll be talking about them now.
Yeah, well, let's open that to the rest of the panel. And what, in your view, what should people be asking for in guidelines? And I don't know if there's anyone who wants to volunteer to go first, or I'll just pick.
So I think it should do all three of those things at some level, right? So we want to be able to describe to the world what the agencies are doing, and in a general way. It has to be general because all of these matters are obviously very fact-specific, but we want practitioners, companies, to have some idea of how the agency is actually analyzing vertical mergers. So the conversation that you have when you go in with a transaction to the agencies can be a robust and well-educated one, and that the companies don't, and their lawyers and economists don't kind of feel like they're shooting in the dark and that theories are popping up that they've never considered or thought of. So I think we guidance for the bar and for companies, and some which hopefully gives some better predictability about enforcement, I think is one very important goal. I do think another goal is to help push legal and economic concepts further where they need to be. And sometimes the courts in cases, just by the very nature of the cases that get litigated, can get a little bit behind in terms of economic thinking and even sometimes creative and interesting legal theories. So where there is ground to be plowed that goes beyond what's currently out there in the case law, I think the agencies, to the extent that they are using those new theories and new economic analyses, should be letting people know that and helping the courts understand what they're doing. And I do think the courts look at these guidelines as helpful to them in analyzing transactions, and they should be. So I think that was your third, was for the courts, right? Yes. And I think that that's another. We know that the horizontal merger guidelines are looked to by courts, and I think there should be enough concrete and specific guidance in the guidelines that courts can look at them and say, okay, I know and I understand that in this particular circumstance, the agencies believe that a vertical transaction may cause harm. I've got to look at the facts, and I'm not going to use that as just an immediate playbook for making a decision, but I at least know what the antitrust enforcers, who are the experts in this area, think about this particular area. And so I think enough specificity in the guidelines for the courts to be able to use them in that way is really important.
So having been part of multiple administrations, at least taking on the task of trying to draft vertical guidelines, I kind of want to commend the current administration for getting this far. What a lot of those previous efforts foundered on, though, I see as still underlying a lot of what's going on here, which is there's a tremendous number of preconceived notions about vertical mergers and very few facts on which those are based. And so that makes it very hard to get to kind of the end product that we're all used to, or more used to, with respect to horizontal guidelines, something that really is very informative to the courts because it has gone through a process of revision and commentary and more revision. I submit that the current vertical guidelines should be viewed as kind of the first step on that dialogue process. And in that vein, I think it's useful to think about what is the one thing you actually can say clearly based on facts is what do the agencies actually do with when a vertical merger comes in? What process do they apply? I find that the draft is very focused on a few examples that I can read as what they might do in specific examples, but they don't say why, so there's still a lot of gray area about how they would extrapolate beyond those particular examples. But more importantly, from what I'm submitting, I would say that they are not saying enough about the details of how. I mean, it's kind of everyone knows that a vertical merger complaint starts or rests mostly on complaints from the customer competitors. But does everyone know that those are vetted? Does everyone know how they're vetted, how the agencies look at things like the vertical arithmetic and say, well, that particular thing never gets to a definitive answer. It does identify, oh, there's high margins, so the real question is, why aren't they already able to extract everything? Why would there be an incentive in this particular vertical merger? Or there's very low margins, and they highlight, well, then do they have the ability to affect the other market? These simple, practical questions would tee up a lot that people could then engage on and say, okay, now that we actually have a consensus on what they do, how does it work? And then we get the next iteration. So to me, this is a very welcome step on a process, but I hope we kind of can be moderate about how far down that process and how close to final guidance that a court could just pick up and use we could achieve in the current step.
Let me just start by saying I very much appreciate the chance to be here, to be on this panel, to be involved in this discussion. It's an important topic, and it's extremely good that the agencies have raised it. I'm going to offer some views that are only mine, right, just personal views. I think they start with this, right? We've had on the books guidelines since 1984 that recently nobody thinks are effective, right? The agencies have been disclaiming them right and left, and yet courts have, and very recently in a litigated vertical case, did cite them. So it's a very good thing that the agencies are moving forward. And indeed, just in moving forward, they've helped emphasize theories of harm that have grown up and been accepted in a series of consent decrees and other cases brought by the agencies. The fact that harm can exist and the nature of that harm, and of course disputed the notion that vertical mergers are inherently pro-competitive. That by itself is a step forward. I agree with what's been said before in two respects. Well, in many respects, only two of which I will repeat. One is, these are descriptive of agency practice. There is a lot more to learn, and so we can't expect the guidelines to be more precise than the agency's understanding, and I think we should accept them in that light. And we should understand that there's more work to do. We are living in a world, of course, in which I believe it's true there are only 2 litigated cases, vertical cases brought by the government in about 40 years. So there's more experience to be had. Secondly, I think it's very important to understand the impact on the courts. The courts have looked at the horizontal merger guidelines, have cited the non-horizontal merger guidelines, and have cited against the agencies instances where they thought the agencies were departing from the guidelines. The Baker Hughes case is a good example of that. So it means that in finalizing the guidelines, it's critically important that the agencies focus not only on how parties should understand the process of investigation, but how courts should understand the roadmap to litigation. Thank you.
Yeah, I'll just wrap up. I mean, I agree with most of what's been said, and I think that, I mean, look, this is a challenging task. Let's all recognize it. I mean, it's challenging because vertical, I think there's consensus. There's not consensus on vertical, there's consensus that vertical is harder than horizontal. Although some appearing in the next panel may disagree with that. This is a hard task because there's 2 agencies. This is a hard task because there's worldwide vertical merger guidelines. But I go with sort of the Goldilocks theory, which is the guidelines have to be detailed enough to be really useful and really specific as far as they can be, but not so detailed that the agencies can't reach an agreement on what should be in there, and or they think that they're creating new policy by making them so detailed. You'll hear this is sort of a refrain I think you'll hear from me later, which is I'm a big believer in the examples that are provided in the guidelines. I think if you look at the IP guidelines or the healthcare guidelines, I have a tendency to think that those are far more useful to the business and legal community than even the text. And I'm a big believer in, and I think Bob was alluding to this, was kind of blowing out the examples a little bit further with numbers and margins and saying things like, you know, here's an example of a raving rival cost theory that we would bring, or we would probably bring, however you want to caveat it, and then have right next to it, same hypothetical, but just playing with the facts in a way that shows that we probably wouldn't bring this one. So, because I think that would be, and the guidelines get there a bit, but in my view don't get there far enough. If there's a little bit more content behind it that the user and the reader can chew on, I think that would be a very helpful next step.
Okay, well, let's turn to some of our hot topics. Christine did preview one for us, which is the safe harbor. We did receive a number of comments relating to the safe harbor. And Renata, can you start us off with should there be a safe harbor? If so, why, and what should it be?
Sure. So I'm here with two hats on. One for the ABA, at which the antitrust section did submit comments, as I can't remember, somebody mentioned. So to the extent, I'm going to start by talking a little bit about answering this question from the perspective of the ABA comments. And when I do that, I should say the comments are the views of the antitrust section, and they have not been approved by the ABA House of Delegates or the Board of Governors and should not be construed as representing policy of the ABA. And if I'm not speaking in the ABA capacity, I'll make clear that they're my personal views. So I do think there should be a safe harbor, and the ABA comments commend the agencies for creating a safe harbor and for doing something which is designed to help companies evaluate the risk associated with a vertical transaction. I think there are two pieces of the portion of the guidelines around the safe harbors that the ABA comment takes issue with. The first is the 20% safe harbor, which the comment suggests is too low, based on looking at similar safe harbors around the world and in other guidelines and guidance that the agencies themselves have issued. The comment recommends a safe harbor in the range of 30 to 40% shares as opposed to 20%. And the other is that the last sentence of the guidance relating to safe harbors sort of takes away the certainty and predictability associated with the safe harbor. And that sentence says, the purpose of these thresholds is not to provide a rigid screen to separate competitively benign mergers from anti-competitive ones. Rather, they provide one way to identify some mergers unlikely to raise competitive concerns and some others for which it is particularly important to examine other competitive factors to arrive at a determination of likely competitive effects. And I think the view of the antitrust section is that that kind of takes away the oomph of a safe harbor because it sort of says, well, yeah, there's a safe harbor, but yeah, we're not really going to tell you what it really means. So the comments suggest, with respect to the 20% share or whatever share it ends up being, that the guidance include a sentence along the lines of vertical mergers with shares below these levels likely require no further analysis. Most of the guidance that the agencies have issued say something along those lines, either unlikely to challenge, unlikely to cause harm. And that the last paragraph of the guidance around safe harbors say that vertical mergers above these levels might require further analysis, but are not inherently suspect. The view is, and I think this is correct, that adding this kind of language will help the guidelines be, and the safe harbor create a little bit more predictability and certainty for people who are doing vertical transactions, analyzing them, and thinking about going forward with them. There's very useful information in the comments about market share thresholds in other screens in other guidance, so I commend those to you on pages 5 and 6 of the guidelines. So you can see that the range of these market share screens is really from 25 to 35%. The agencies themselves have commented in certain circumstances that the jurisdictions have had screens that are share thresholds that are too low, and I think we want to make sure that in the world of international antitrust, that the agencies aren't seen to be advocating for something that's inconsistent with both their advocacy abroad, but also with international norms. And I guess finally, I would say the purpose of having screens like this that is truly pro-competitive is that we don't want a screen that's so low that it potentially chills benign or pro-competitive vertical mergers because they don't fall within the safe harbor. And again, we want companies to have delineated guidance that makes it possible for them to feel comfortable going forward with transactions that, as Commissioner Wilson said, are likely to be pro-competitive and beneficial to consumers.
I guess just a couple of additional thoughts on that. I mean, it was funny, when I first saw the 20% screen, I thought, and I think I read all the comments, I thought I was going to see, oh my God, it's so low, it's not reflecting reality. That's my position, is that it doesn't really reflect the sort of vertical questions that we've gotten from the agencies have been typically far higher than 20%. And that's not shocking. What was shocking to me was that there were a lot of comments, and from economists no less, who were saying that that was going to chill enforcement. It's just when I was in the FTC in the mid-90s, we were largely focused on evasion of rate regulation, vertical merger enforcement, and good luck finding economists to support you. And now we got the economists who are actually the ones who are kind of pushing the aggressive side of some of these theories, which makes it really fun and interesting. Yeah, I'm sorry. I think where the section is, I think it probably should be increased if it's kept. Not that my practice is perfect representative of others, but I suspect that, most questions that people get from the agencies are not in the 20, 22, 25% range, that it takes a different set of circumstances to create that kind of market power or foreclosure effect. And if the story is involving a 20% player, a 25% player, my view is you probably have the wrong market, and it's probably a different set of related products or market that probably has a higher share associated with it. And you can get into questions as to whether we should be defining markets at all or not. But I just think that the set of products over which the hammer is being provided in vertical mergers is going to typically be higher than what's the screen at now.
If I could, Bob, you want to go first? I might take a little bit of a different view. We've talked about the fact that these guidelines are essentially descriptive, and that's their strength. But it's not clear that this safe harbor with this standard is descriptive of current agency practice. In other words, there may be different mergers looked at it with different kinds of market shares or shares of sales and related products. But there's no obvious basis for the use of the 20% number. This is something I think is echoed in comments from a variety of perspectives. So it would seem that if we don't have the basis for this number, and I'll talk about other ones, that the right thing to do is to treat this as part of the question that remains to be answered. In other words, the vertical merger guidelines can do a lot. They need not do everything if the agencies don't yet have the experience to codify a safe harbor. It seems to me the better course would be to gain experience and identify when concerns are likely to be lessened or increased, right? Let me give an example of a circumstance that actually comes out of Section 7 of the draft vertical merger guidelines, in which a market share of below 20% can certainly support an antitrust theory, and that's if one has a maverick, right? We tend to talk about vertical in terms of unilateral theories, but of course, coordinated effects are just as applicable. The elimination of a maverick with 15% can shift competition, can allow people, other rivals, the ability to raise prices, can facilitate coordination. Traditionally, what a maverick is an entity that's disrupting the ability to coordinate. And I don't think that the existence of the maverick is dependent on whether it has 20% or 30% or less than 20% of market shares. Similarly, the healthcare market. The Assistant Attorney General was very kind to refer to the comments of 26 state attorneys general, which discuss this issue, and which point to the specific nature of parts of the healthcare industry to show that firms with market shares as low as 13% are viewed as significant parts of a highly concentrated market. The Federal Communications Commission, in its comments, talks about circumstances in which inputs are technologically necessary and users would have to incur significant fixed costs to substitute away from the input. But those fixed costs are not necessarily dependent on the market share of the input provider. So there are a series of reasons to believe that the 20% doesn't provide clear demarcation. The language of the vertical merger guidelines, the draft, is, I think, expressive on this point. It doesn't treat it as a yes or no binary decision, but I think the better course would be to understand that our state of knowledge does not yet get to this level of precision on this or any other number, and to gain experience as the agencies move forward before any such safe harbor were adopted.
Just one brief thing, because I think I agree with all the comments that have been made, but I think some of the confusion or some of the variety of what is or is not a good number stems from the fact that while we're very used to using shares as a measure of substitutes, in vertical mergers we're dealing with complements by and large. And it's not a well-defined concept to say the market share relates to power in some way when you're talking about shares across things that are complementary goods. And it, in fact, is very hard to even say what you mean by a share when you're talking about something like, well, in the AT&T case, it might be 20% of the revenue or 20% of the channels that are on any given MVPD's lineup, but it's on every single MVPD's lineup. Is that a 100% share or a 20% share? Intuitively, those have very different implications. We're not measuring something very meaningfully when we talk about shares of complements.
Just one quick thing, which is merger review is extraordinarily expensive. Everyone here knows that. And without some number to point to the staff and say, you know, your own guidelines say you shouldn't be looking at this, the process can take longer and cost more money. I completely get the concept about Mavericks, but then you're proceeding on a different theory than a foreclosure theory. If it's really going to be a foreclosure theory, let's have a number and let's be able to tell the staff, you know, when the time is right, that, you know, this deal should be cleared.
So this is not from the ABA comments, but I think one of the things that John's example points out is that one of the issues, I think, with a safe harbor is that it suggests there should be symmetry in the shares in some way between the two parties to the vertical merger. And I actually think Greg's looking at me with a quizzical look on his face, but I think Greg was actually the one who pointed this out, that you might have a situation where one side of the merger has very low shares and the other side has high shares, and where that either could be okay or not okay. And it's not clear that we should be looking at both sides of these transactions and the shares of both sides of the transaction in the same way. And I think that's partly Bob's point also, is that they are complements typically in vertical mergers, and so it's a little bit hard to judge how they're going to interact and potentially either foreclose or do other kinds of harm.
Thank you, Renata, and the whole panel. And that flows nicely into the next topic, although I'm sure we could probably spend more time on safe harbor. And that's market definition. And Bob, the draft guidelines require defining a relevant market and identifying a related product. In your view, do the draft guidelines get these concepts right?
So there's pluses and minuses to this approach. I happen to be a fan of the approach overall, but I think because I come down on the side of one of the big pluses is that it highlights the fact that a vertical merger's effect, any competition happens in a horizontal market. And by focusing on there is a relevant market that is affected, the draft guidelines emphasize that at the end of the day, that's what we're talking about here, even in vertical mergers. We're talking about some market that has its horizontal competition affected. It's new terminology. It's got loose things to it. It's going to be difficult to get your head around exactly what it means, but at that level, that's a positive contribution. One of the things that I think is a particularly big negative of it is that by not defining a market for the related product, the one bringing the ability to influence this competition in the relevant market, it makes it very hard to then talk about something like shares that product has in its market. So instead we have this concept of how measuring its share in terms of how much it's used in the relevant market. And that becomes a very convoluted mess. I think, personally, I don't think there should be a share-based threshold. I think the concept that we're trying to get across with that is, does that related product convey this ability to actually affect the other market? If you identify or can come up with a way to articulate a safe harbor around, that is something that at the end of the day, the agencies are going to be looking for, this ability to influence. I think that mitigates one of the biggest problems of defining one market and talking about a product in the other side of the merger. That being said, I think there are some practical issues with defining markets in vertical mergers that by just referring to, we're going to use the tools that we use in horizontal mergers, the guidelines gloss over. In particular, in a vertical context where the stakes are not just we're going to move slightly within, we're going to nudge the equilibrium a little bit. We're going to have slightly different competitive structure that's going to tinker with the outcome close to what we've observed in the past. So market definition can be premised on the kind of marginal change, a small but significant increase in price. Here we're talking about things that are potentially existential effects. Am I going to threaten your existence altogether? Well, that seems like it generates a whole different set of considerations in the mind of the customer competitor, than if price were to go up 5%. And we should be cognizant in doing vertical merger market definitions, particularly when we're talking about the ability aspect of this, that the set of products or the set of choices that we're trying to get to when we think about what is the ability to influence this market really premised on, that may be a question not of if prices went up a little bit, but a question of if my existence as a company were on the line, where would I go? And we ought to think through what kind of market definition, if we're going to do market definition around this kind of product, is actually appropriate.
So I personally find the concept of relatedness pretty ill-defined in the guidelines, and I think the ABA comments mention that as well. And I actually find the discussion confusing and unnecessarily so, and maybe I'm just not economically inclined enough to get it, but it seems that we've gone away from describing things as upstream and downstream for some reason, and I don't really understand what the point of that is. It seems to me we should use the language that people typically use in talking about vertical mergers, and adding in this kind of ill-defined concept of a related product market and without much guidance about what people are supposed to do with that. How do they identify what's a related market? How close do the two related markets have to be? How much work do you have to do to define that related product market? It just creates a lot of unnecessary confusion and potentially will create a lot of unnecessary work for people who are coming before the agencies with a vertical transaction. So my personal recommendation would be that the agencies kind of rethink using that concept entirely and go back to the language of upstream and downstream markets. And if there's some reason why upstream and downstream don't work, explain the situation where that is, and adjust and talk about that specifically in the context of the guidelines.
So I suspect, with no evidence whatsoever, that one of the reasons for calling it related product rather than downstream market is that the agencies would rather, when they go to court, not have to formally prove two relevant markets. It's a lot of work, it's a lot of proof, and I completely get that. But if there are really good substitutes for the related product, that tells you a lot about the case, and that needs to be incorporated into the analysis.
Mine's easy. I agree with Renata. I've learned over the course of my career to do that as often as I can, so I'm going to do it right now, too, and just agree with you.
I just want to stipulate I always agree with Renata, if I could just do that. So look, I do think this is the agency, the drafts do something important here, right? The goal of the analysis of mergers is not to define markets. The goal is to specify whether there's a likelihood of anti-competitive harm. We know from the horizontal merger guidelines that market definition is not always required. There are times where direct effects can be demonstrated. So the notion of helping us understand effects, and it's useful to just take a moment and understand, there's no such thing as vertical harm, right? All harm is horizontal. All harm has a horizontal effect, but the mechanisms of harm are what we describe as horizontal or vertical. So in understanding vertical, obviously, there's a relationship between upstream and downstream. I agree with Renata. I find those terms helpful, even if sometimes economists tell me I have to turn them upside down. But I do think the agencies are right to not get locked into a notion where market definition is invariably necessary. Of course, if one is looking at the share of sales into a market, there can certainly be in various transactions other questions that arise. What's the shares based on? To what extent could someone, as Craig says, substitute out? But I do also think that if we look at some economic literature on input foreclosure, Professor SALLET is one, what we see is that it may be that the critical question about the input is not the share of the upstream market, but its criticality in other ways to the work of what would become the rival to the integrated firm. So I can imagine a world where there's additional inquiry that takes place beyond the share of sales, but where there is no formal market definition necessary. And it strikes me as useful to not have to define markets if anti-competitive effects can be otherwise proven.
Can I make one follow-up comment, David? I apologize. So, I'm sorry, Bob, did I cut you off? You know, the practical issue, at least as an outside lawyer, I'll go back a little bit on what I said about agreeing around it. It almost doesn't matter what you call it. It's sort of your point, I think, Jonathan. It's when you sit down with a company that's doing a vertical merger or horizontal merger, whatever it is, you can call it a market, you can call it a related set of products, you can call it a tying market, you can call it the upstream market. The question, at least I asked the company, is there some set of goods or services that you have that's so critical to the downstream market that you're going to be able to strong on them, God forbid, leverage them, do something to foreclose them that's going to affect the downstream market. That's the problem that we sit down with General Counsel and try to explain and say, this is what you're in for if you do this deal and you have competitors coming in and talking about it. So, I think it's an interesting academic exercise in terms of what we frame it and how we do it. It's probably more of a litigation issue, ultimately. But in terms of the counseling element of it, that's the practical way which at least I sit down and talk about it, and that means maybe the nomenclature doesn't matter as much.
Yeah, I just wanted to add one more thing on the kind of the labeling issue, and I fully appreciate that coming up with new terms it's got its own risk. One of the things we're getting rid of with the 84 fragments is actual potential entrants and other terms that they don't have any intuitive understanding. And I get that, but not only do we have to, in vertical guidelines, have the ability to turn it upside down and tell the exact same story with a different flow of commerce, we have to turn it sideways as well, because a lot of these same vertical theories apply to just mergers of complements that don't involve any actual vertical exchange of the goods or services. They're both bought by the same customers. So, with the caveat that this is going to mean more explaining to people, when it says relevant, it means downstream in your case. With that translation, though, I think the labeling does stop mattering. It is just a matter of the market that's affected and the place that the ability to affect that comes from.
Well, let's turn to scope now. We've received a number of questions and comments about what's covered by the vertical merger guidelines, including whether diagonal mergers are covered or combinations between two firms in a long supply chain. So, Jonathan Jacobson, how literally should we understand, or do you understand, the V in the VMG?
Sort of. Maybe we could put up that one slide that I gave you. Yeah. So I'll get to that in a second. But the guidelines have a very general description of what is an anti-competitive effect. In terms of what is a vertical merger, there is a definition in footnote 2, and the definition talks about the same supply chain. I've taken that to mean that vertical mergers are customer-supplier, and I believe that's correct. But what about a case like Staples Ascendant? Ascendant was a distributor, but Staples did not use Ascendant. So is it a vertical merger? I think the better view is to put it in what may be a very broadening diagonal category, but there are reasons for addressing truly vertical mergers, customer-supplier relationships that have very different issues than purely conglomerate or diagonal mergers. Now, as I said, I think the guidelines are a little bit thin on the catalog of potential harms. So we put this slide together to try to broaden the capture. And I'm sure we haven't gotten everything, but let's go through a few of them. So input foreclosure and customer foreclosure are fairly standard, have been in many cases over many decades. Bargaining leverage is new. Aviv Novo is here. He's the leading writer on the subject. It's really his theory. It was used unsuccessfully in AT&T Time Warner, although the Court of Appeals decision seems to endorse it in principle, if not on the particular facts of the case. It was the basis for the blocking of the Comcast Time Warner merger a few years ago, and it's an important theory. There's also, raising entry barriers by requiring entry at both levels. That's actually right out of the 84 guidelines. I think it's the one part of the analysis there that has survived. And then you can describe vertical effects as, they've been in the cases, they've been in the literature, but there's some that are just out of the mind of Steve SALLET, and Frankenstein monster is one of them. And that's where the acquisition, if the vertically integrated firm is going to serve itself, just leaves one unintegrated supplier or customer for the rivals. And the effect of the acquisition there will be to give that unconstrained supplier effective monopoly power. There are also coordinated effects, as John was talking about. I've listed them here. I think they're all, fairly easily understood. There's the evasion of regulation. I shouldn't have said that that was the only, that the 84 guidelines were just entry at both levels. They did mention evasion of rate regulation as well. So I think having a broader discussion of the potential anti-competitive effects would improve the next edition of the guidelines.
Does you just want to comment specifically on scope before we kind of flow into the broader discussion of effects?
So, I mean, I'll jump in quickly on scope. I mean, I do think the guidelines need to be very careful not to suggest that somehow these the agencies are now thinking about conglomerate effects, and the ABA comment addresses this issue also. I don't think they leave that impression, but I think it's important. Conglomerate effects. So I think there should be, you know, maybe an explicit recognition that there's nothing in the scope of the guidance that suggests that somehow conglomerate effects are coming back to life in the U.S. I think John's comment, and this is my personal view, is you know, labeling is very, very hard. And I think one of the things, actually, I'll go speak about Greg again. One of the things Greg taught me is that applying the labels to things isn't necessarily the right way to think about them. Instead, you should really think about, as John was describing earlier, what's the mechanism of harm that's occurring, and how is that mechanism affecting competition? And then you can think about how to describe that to a court, but trying to put things into boxes of particular types does sometimes lead to confusion about what kind of transaction it is exactly that you're talking about. Now, when you're talking about guidance, I do think it's good here to say, it would be good here to say, we're really talking about vertical transactions here, and that this guidance really applies to vertical transactions, because I think, and not necessarily diagonal ones or other types of transactions, because I think the guidance is really tuned to this kind of customer-supplier relationship, and that would be a helpful addition.
I agree that we don't necessarily want to just throw the door open to conglomerate effects, but I think that there are an awful lot of industries, including extremely important industry, where most of the deals that are going on, healthcare, are not literally supplier distributor or vendor, vendee, whatever it used to be called. But they have the exact same underlying economic issues, and the same antitrust theories are going to apply to them. So whether you say these guidelines cover that or not, they're going to be applied to those by somebody. Somebody's going to argue that they ought to apply to get whatever presumption, or not to get a presumption. You know, this is, I think it's worth the agencies just taking the time to say, especially with such an important industry kind of teed up like that, the guidelines are meant to cover the vertical issues which can happen in mergers of complements.
Yeah, let me just add, because I agree with Bob on this point. Let me say what I think we wouldn't want. We wouldn't want a world in which there's horizontal merger guidelines, vertical merger guidelines defined strictly speaking as to whether companies currently have a customer-supplier relationship, and then this other stuff. Right, because that would create confusion. The agency would not have spoken to the other stuff. There'd be awful lot of argumentation about what is or is not the other stuff. I think Bob's recitation of healthcare is a good example of places where it's not as neat and simple. And in fact, I think there's some debate about what is or is not vertical, even in its strict sense. And so if one could, it would be better, I think, to have the guidelines apply to the extent the principles do, right, to what one might say, if one were to go back to the 1984 guidelines, are non-horizontal issues, so that there isn't this possibility that there's a set of transactions that seem to be uncovered by agency guidance. The last point I just want to say is, I agree with John. I think the potential harms, the theories of harm in the drafts are very good. John's list contains others that I think ought to be noted, like evasion of regulation, just as one example.
So kind of picking up on the John's commentary, so we have in the draft guidelines, there's a specific explicit mention of raising rivals costs / foreclosure, and access to competitively sensitive information in terms of potential anti-competitive effects that could come from a vertical merger. But as John's slide helpfully illustrates, there's more theories out there and more potential effects out there than are explicitly listed in the guidelines. And I think we've already started this discussion that at least some folks up here think that the guidelines should be expanded and should cover those other theories as well. Does anyone have a different view or want to weigh in?
Well, I'm not going to have a different view than my prior view, but I thought I might expand on it a little bit. So the effects on the slide are geared at customer supplier. There's also an important distinction between EDM in customer supplier relationships and cases like Staples Ascendant, where there can't be any cost savings if you're not doing business with them. And I do think the guidelines need to take the scope issue that we were just talking about into account in describing the potential harms and also the potential benefits from, eliminating double marginalization.
Yeah, so from my perspective, this is the harms effects area. To me, is the place that I think the guidelines could use the most beefing up. Is my sort of biggest issue. It's a hard task. I said it at the beginning, but I go back to more building out of what are the scenarios that the government's really going to find to be a problem and which are they not. And that's for a couple of reasons. One, I just think it's a little thin in terms of what equals a raising rivals cost problem. There's a lot of problems. There's a lot of equations that raise rivals costs, and we can get into margins and diversion ratios and things. I think further explanation of that would be extremely helpful, extremely necessary. I think there's a practical problem that I think hasn't been discussed today that I kind of suffer through sometimes, which is that part of the reason why I think the effects should be blown out a little bit more, and it relates a little bit to the 20% threshold, is because I think we have to recognize that, at least I feel, there's an opportunism issue that competitors can take advantage of in this process. My view is that a customer weighing in on a horizontal merger, is a less biased witness than a competitor coming in and speaking about the harms of a vertical merger. I think naturally, I don't think that's very controversial, but I think when you have that dynamic and you have a situation where the agency have been pretty clear they're not going to be favoring behavioral remedies, and that competitor sees an opportunity, whether they have a 21% theory or whether they don't really explain in the guidelines the kinds of effects that they're going to recognize, I think it creates a dynamic, or it could create a dynamic where competitors will increasingly come in and try to take advantage of the HSR process, slow matters down. I guess that's all fair in love and war, and do it for a couple reasons. One, because it causes pain to the company and slowing it down a very large transaction, or two, because the agencies are down on behavioral remedies because that third party is seeking some kind of private fix. They say, hey, we have an issue with this transaction, but we're going to go in and use the guidelines and talk about why there's a problem, but that wouldn't be necessary if you gave us a new supply agreement or a new contract or something. So that's not perfectly solvable by the guidelines. That's an inherent incentive issue, and I think a witness bias issue personally. But I think expanding greatly the sort of explanation of the effects and the harm would at least help that problem.
On unilateral, I mentioned regulatory evasion, which is important, and Professor SALLET has written about over the years. Two others that we ought to think about. One goes back a long way in vertical, and that's two-tier entry, right? That can be a theory of harm, that the effect of the integration, particularly of multiple firms in a heavily concentrated market are vertically integrating, that the costs of entry are being raised. Secondly, this was mentioned before, I think, but I do think some additional emphasis on bargaining leverage is helpful. It is certainly in the examples, but the particular instance which I think the current draft doesn't call out a theory of harm comes from buyer side power, right? One can have buyer side power, one can have monopsony, to use the horizontal counterpart to that. Scott Hemphill and Nancy Rose wrote a very good piece on buyer power in the Yale Law Journal a couple of years ago. And it's important for two respects. One is it is a mechanism of harm that should be recognized. Secondly, sometimes people get confused about where the harm must be from a monopsony or buyer power kind of claim. It is focused, to use the terminology, on the upstream. And that's an important part of analysis that also can be clarified and captured.
So I can't help but look at this list, and every one of these I can see a particular economic model, maybe a specific paper. I'm sure the other panelists up here look at them and can see a particular legal case. There's a tendency to write these up as, and write the guidelines up where and this is, I agree with Craig that more flesh around what it is that you're trying to do in processing vertical issues is useful, but I worry that going to more and more examples and more detail on specific examples misses the fact that, you know, in some sense, or at least in my experience, every complaint that comes in, the facts of that particular industry are unique enough that they don't exactly fit any one of these stories. And every time you're kind of building a story around what is it that they can do or can't do, well, to be completely clear and to deal with, you know, to help a little on the opportunism point, I think it would help a lot to just point out that as these complaints come in, the agencies, usually those complaints fail to articulate something that can be a set of facts that can be applied consistently to the pre-merger and post-merger environment and get a coherent story at all of any kind of vertical issue. But the ones that do, I think, are general enough that we ought to be able to articulate what the general principle is. And we ought to be able to flesh this out by saying, what do these stories have in common? What are the things we're actually looking for? And whether at the end of the day we can articulate that as a share threshold or something about the nature of contracting or particular kinds of efficiencies, what do they have in common that you're, as a procedural matter, trying to sort out when they first come in? And what do these stories have in common? That, to me, would be the better way to flesh this out, because at the end of the day, no one theory or no set of theories, no matter how much that particular, and I'll just pick on raising rivals costs because it kind of is the quintessential economist exhibit, no one theory fits every case very generically, but they all have enough in common that you could get to that fleshing out with, and to the guidance you actually need to give without having to just say, these are the definitive list. And right now the guidelines try to not give a definitive list, but just give a list and kind of leave a lot unaddressed in between the elements of that list.
That's kind of the Goldilocks theory, right? Which I go back to, which is it's got to be, my view, detailed enough to be useful, but not it's not the tax code, right? You can't just look it up and say, here's my answer. It's got to be detailed enough to be useful. I mean, I'm sorry if I'm stepping on toes for others who are going to mention it, but this whole concept of de minimis standard that's sort of in there, it's very unclear what that means. And I think that's one of the places that's the least clear, frankly, and that ought to be clarified, I think, to your point.
So I do think John Sallet just pointed out something very important that's missing from the guidelines, and that is, it's implied, I think, but it's not explicit there, and that is whether or not the agencies are concerned about upstream harm or downstream harm or both. The examples talk mostly about downstream harm, if I remember them correctly. But there's no explicit statement that what you're looking for is harm in a downstream market. And so if that is what the agencies are talking about, I think the guidelines should be explicit on that point. And this is again a point that's made in the ABA comments. But if, as John points out, there are situations where upstream harm is something that the agencies will be concerned about, that should be explicit as well.
Or at least just explain, what issues the agencies will be looking at, under these or, other categories. The categories aren't airtight or exhaustive, but if they could be used as a basis for explaining, how competitive harm occurs, I think that would be a useful contribution.
Let's shift gears a little bit from harms to everyone's two favorite topics, EDM and efficiencies. So Christine previewed some of this with respect to her view on this morning. Jonathan SALLET, what is your view on how the BMG should treat EDM?
My fundamental view is that the first time I heard the phrase EDM, I thought we were talking about a 90s rock band. But I've learned that that's not the case.
It's actually electronica music, but that's okay.
Then I would not know either the law or the music. So I think, well, I want to express a different view from Commissioner Wilson, respectfully. And I want to go through 5 reasons why I think the law requires, the DOJ precedent supports, and logic dictates that elimination of double marginalization be viewed as any other kind of competitive benefit that parties put forward to assert that any likelihood of anti-competitive harm will be nullified. It's important to understand that is the mechanism here, right? We're talking about a world in which the antitrust agencies in litigation establish a prima facie case, and then the question is, can the merging parties offer evidence on any reasons, and multiple reasons, as we saw in the recent T-Mobile Sprint decision, to think that that anti-competitive potential will be nullified? So 5 reasons. First, whatever these guidelines say, it's going to have impact on the courts, for sure. And by having elimination of double marginalization in a separate section from the other kinds of competitive benefits, traditionally labeled efficiencies, it's going to be a recipe for mischief in litigation in which parties say, well, it can't be the same. All this case law about efficiencies, that can't apply here because it's in a different section. It's a different kind of structural presumption, one might say. That is to say, the structure of the guidelines themselves. That would be confusing and unnecessary. Secondly, the guidelines ought to follow the very clear and explicit position of the Department of Justice, right? Last year, the Assistant Attorney General gave a speech, February of 2009. We talked very directly about EDM. He said if they, the merging parties, want credit for EDM, then they have to do the work and have the evidence necessary to support it. He described it as an affirmative defense, the burden of which is on the parties, and expressly said the Antitrust Division is not required to present in its case in chief evidence rebutting or anticipating the defendant's affirmative claim that EDM will cause a price decrease. This was also the formal position of the department in the AT&T Time Warner merger. And that's a sensible position to take because it reflects the governing legal standard, which the Assistant Attorney General also discussed in his opening remarks this morning, right? Think about AT&T, the D.C. Circuit opinion. Think about past cases. Section 7 is a predictive statute. It looks to incipiency. It doesn't require proof that harm will occur. It looks to a substantial lessening of competition, which the courts have told us can be understood as a reasonable probability of harm. That's exactly what the D.C. Circuit said in AT&T Time Warner. It talked about the purpose of Clayton Section 7 as trying to prevent incipient monopolies. It talked about reasonable probability. So then the question is, the burden, as it were, is to demonstrate that that reasonable probability isn't going to come about. That's what the rebuttal case is. That's the defendant's burden. And in thinking about how burdens lie, this is my third point, legal standards traditionally look at who has the information and the incentive to develop it. And it seems to me it's very clear here that that's on the merging parties. The comments of the state attorneys general discuss this in more detail than I will, but there's a number of questions, fact questions, on which the merging firms are going to be in a better position. Superior knowledge of what margins existed in the past. Knowledge about what actions, if any, have been considered in order to align the interests of the upstream and downstream firms. What incentives to eliminate margin would exist post-merger? And why would actions in the future remove any past impediments to alignment? And this is another point. I think people who've been through antitrust investigations, whether in the government or private sector, it is not uncommon for the pro-competitive benefits claimed by the merging parties to shift during the investigation. Because they know more. Mergers can get announced quickly, and then there's a lot of work to be done. And I was in one merger investigation where somebody took a graph of the claims of efficiencies, I'll admit, efficiencies over time from the beginning of the investigation, and the number went up and up. Doesn't mean it's not a good number, but it does mean that the parties, even when they're getting to court, are thinking about what's actually going to happen, as they should. That's their incentive. But it also is another reason why the agencies shouldn't be put in the position of trying to guess at what the parties themselves are going to think is going to happen post-merger. Fifth point. I'm not an economist, but from a lawyer's view, there's not enough in the economic analysis to overcome the statutory standard and the precedent and the basic notions of law about where burdens are placed. And in this regard, there's important materials, right? There is a case, we do have a case, of course, Comcast NBCU, where the Department of Justice looked at facts and specifically found that double marginalization was not likely to be eliminated precisely because of previous contract negotiations between programmers and distributors. And in fact, that industry, video, is one where take-or-pay contracts is pretty common. But more than that, there's a question about the literature and how it can be read. I think the two sets of comments that are very important to look at are the first that were put in by Professors Baker, Rose, SALLET, Scott, Morton, that conclude that the economics literature does not support the proposition that there is a reliable relationship between EDM and raising rivals' costs. Professor SALLET tells us that there are multiple models, some of which show a relationship between EDM and raising rival costs, others do not. Professor Scott Morton with Marisa Beck put in comments very expressly going through the literature and concluding on her review that the literature does not show that vertical mergers are generally pro-competitive. And Professor Carl Shapiro, an expert in Time Warner and AT&T Time Warner, and whose comments are cited in whose views are cited in a number of comments, filed his own comment in which he says very straightforwardly, I support an approach under which EDM, like all other efficiencies, must be shown to be cognizable before it can be credited. So just to sum up, it seems to me the Assistant Attorney General, in stating the position of the department in going to court in AT&T has taken the correct position, accords with statutory law with its own understanding of cases, and that therefore the vertical merger guidelines ought not be issued in a way that suggests a differential treatment in terms of the process by which elimination of double marginalization and other efficiencies are assessed.
One has to be crazy to disagree with John SALLET, and so I will confess to being a little crazy. So it's important to look at the scope question before we dive into EDM. The paper that John referred to by Nancy Rose and other authors takes as its universe deals that are not customer-supplier as well as deals that are customer-supplier. EDM is virtually inevitable in customer-supplier mergers. It is very much not inevitable in other mergers, and I think one needs to make that distinction quite carefully. The problem, the reason I think that the guidelines have it right to have EDM in a separate section stems largely from that fact, that it's pervasive in truly vertical mergers. It's also, let's talk about the efficiencies defense. I completely agree with John that there has to be a burden on the defense because they have the facts. I would make it a burden of production rather than of proof, but the one thing I would certainly not do is impose the same unbelievably strict standard for proving efficiencies that exists in the horizontal merger guidelines on an efficiency like EDM. So, you know, the Seller-Kefauver Act was passed in 1950. 70 years went by until T-Mobile Sprint was the first case ever to recognize an efficiencies defense in a merger case. And to apply that strict of standard to a cost savings that, you know, in properly defined universe of vertical mergers is pervasive just strikes me as the wrong approach.
Can I raise one? I confess I don't have fully formed views on where it should be in the guidelines, and I'm still working through it because I think it's an interesting issue. I guess I have a question I might suggest I do, even though I really don't, which is maybe to John or others, which is if there is a burden of proof on the defense team to show that these efficiencies exist, do they have to prove that contracting wouldn't work? And if they have to do that, do they have to show that the parties have tried it and it didn't work? I mean, that strikes me as you're proving the negative. That's you'd be telling your clients, until you take advantage of this efficiency, you got to go out and try contract, which I don't think is going to happen in the real world. But you see what I'm saying? There's a practical issue there, which I'd be curious about your views on. Well, you, but it doesn't ever to everybody.
Him, John.
Sorry, I'm not a moderator. I don't get to ask questions, but I'm just curious what the answer is.
It's a question of fact, right? The burden, however one wants to phrase it, is on the merging parties to offer evidence that negates the risk of anti-competitive harm. They can do that in any way they want. The judge can assess it any way that she wants, right? It isn't detailed as to whether you have to show something about a contract. If there is evidence of past, in Comcast NBC, there was evidence of past contracts that one could look at and say, well, gee, it looks like the double marginalization was effectively eliminated. That's a set of facts that merging parties can respond to. But it's in the same framework as always in terms of negating harm, which means, can I just say one thing about what John said? Because, I mean, I think the question of EDM being always or pervasive or inevitable, if it's truly inevitable, then it will always be effective with the agencies and the courts, and we don't have a problem from that perspective. I don't think it is inevitable. I think it's a fact issue. But I do want to say one thing about this question of the efficiencies defense being unbelievably strict. I think it's really important, and I'm now talking about horizontal, but that we understand the subset of cases in which the efficiencies defenses are being assessed. In other words, you know, 2,000 HSR filings were made, I think, in fiscal 2018. 1,500 of them or something get early termination. About 500 remain. About 5% of those go to second request. The second requests tend to focus on the circumstances where the structural presumption exists, although one might say the horizontal merger guidelines also ask for scrutiny of even moderately concentrated mergers, but the cases tend to focus on the places where, by market concentration measures, the harm is the greatest. Those tend to be the cases that go to court, 4-3s, 3-2s. And so it's not surprising that we have a circumstance where the burden on the efficiencies is the highest, because the selection criteria have put us in the cases where the risk of harm is the highest. And so I don't think one can take from the way efficiencies have or have not worked and that limited subset any general statement about the way the agencies treat efficiencies. I think the burden is properly applied, and the parties sometimes meet it, often don't, but it doesn't suggest that there's a problem with the legal process.
Just one word, Bob, and I'll let you come in. On contracting. I think contracting needs to be looked at pretty carefully, because in my experience, most contracting measures of the sort that you're describing are done because vertical integration is impossible. Either it's going to be an antitrust problem or it's simply a relationship issue. And so it's a second best solution, and to characterize it as eliminating the problem, I think, overstates.
To say, and all I'm saying is I think we are agreeing that this is a fact issue.
And let's let Bob weigh in here.
I'm going to, I think, John, to not agree with either Jonathan and therefore demonstrate just how crazy I am. So I think one of the things, as we talk about EDM, it's important to, the draft guidelines have given it this weird role where it's neither fish nor fowl. It's not in the efficiency section, and it's not in with the stories that people talk about it being intimately related to, the raising rivals costs theory, right? If it seems like it's left hanging with this weird role. Now, to some extent, that's strange if you're thinking of EDM in and of itself as a theory that does apply in certain contractual situations. At the end of the day, all of the EDM also stands for kind of all the efficiencies that one might expect to happen in vertical relationships. It takes on that role in no small part because it's the easiest one for economists to put into the mathematical models. It just has this nice mathematical property. We use it all the time. That doesn't mean it applies all the time. It's just, it's the easiest way to capture a bigger concept. That bigger concept, I think, is important to think about in vertical mergers. I think it's entirely appropriate to recognize that, we are all used to thinking about efficiencies in a horizontal setting where mere cost savings, the overused firing of one general counsel, are kind of corrupting what we think about. Whatever one makes of those kinds of claims, they taint what we think about actual efficiencies, real resource savings, not just savings on the accounting cost measures, but actual being able to do things more efficiently. And it is possible that that is more likely to happen in a vertical context, in a vertical setting. But at the end of the day, vertical theories, vertical issues arise because things are difficult to do by contract. That's why vertical mergers happen in the first place. That really has nothing to do with whether the thing that's hard to do is pro-competitive or anti-competitive. It's just the fundamental reason that you do a vertical merger is because it's hard to get along with your trading partners and do something that collectively you would like to do. So contractual difficulty is at the heart of everything we're doing when we talk about vertical issues, and it ought to be the case. People who say, well, EDM ought to have a special role because it's tied to the particular contracting difficulty that gives rise to a raising rivals cost theory of harm. That is true. To some extent, that means that if the government is going to prove the contractual difficulty exists pre-merger, that gives rise to a raising rivals cost concern, they have helped establish the factual foundation for there being an EDM consideration. And the parties ought to be able to build off of that. And if this is inherent or it happens every time, it ought to be something that can be shown more often than we're used to thinking about efficiencies being able to be shown. With that in mind, I think EDM, the concept, EDM standing in for all efficiencies of interacting with your vertical trading partners more efficiently, should be a part of what's in the vertical guidelines, but in the sense of it should be treated as all the efficiencies, because there are a lot more efficiencies. Just like we had that long list of vertical harms, every one of those ties to a particular contracting difficulty. Every one of those contracting difficulties can be tied to something that's difficult to do pro-competitive through contracts alone with one's trading partners. All of those efficiencies together should be recognized as, to some extent, being relevant to the analysis. Now, the other Jonathan can disagree with me about how relevant or where it should fall, but to some extent, the idea is the government is proving that there is a contracting difficulty in the first place when they say there's an issue, and parties ought to be able to build off of that contracting difficulty and say, and that means that we are already not able to do something that might be very good. The last thing I want to say on this is there's a notion that because two of these contracting difficulties may lead to, one leads to raising, the same contracting difficulty leads to raising rivals costs as to EDM, that those are somehow more important than another phenomena that happens in vertical mergers all the time, which is there are two contracting difficulties. And if you solve one of them, you might get an anti-competitive effect. If you solve another one and go in a totally different direction with your relationship to vertically related companies, you might get I forget which one I said first, but you might get a pro-competitive one way and an anti-competitive another way. The government has an obligation to kind of weigh both of those, I think, and I think even Jonathan's pro-competitive benefit accepts this. The two visions of what might happen don't have to be squared. To some extent, that is exactly why in the past vertical mergers have often met with behavioral restrictions, because that's an easier way to test and commit on the part of parties to, we actually envision this state of the future world more than that one. We're willing to commit not to pursue that one in order to allow us to go after this pro-competitive one. If you're not allowing something like that, or if there's not some explicit mechanism to arbitrate over that kind of thing, or come up with a better way to contract around the problems that have arisen in the past with behavioral remedies, you are left in this situation where you have to test two alternate visions of the future, and that's not actually any more unlikely or unreasonable than testing two possibilities that happen within the same contracting difficulty. So I think that is a problem vertical merger guidelines face a problem that is unaddressed in the current draft vertical merger guidelines.
Well, this has been a very good and interesting discussion, and we're out of time, but I'm still going to ask one more question for the panelists, although ask for concise answers. And that is, if you could only change one thing in the proposed vertical merger guidelines, what would you change? And then what's one thing that you wouldn't let anyone else change?
I guess I'm going first. I had my thing that I would change, but I forgot about the things that I wouldn't change. I would change the related product concept and go back to a nomenclature that more closely reflects the way people think about vertical transactions. That's the one thing I would change. I'll think about the other one as the other guys go.
So I would not change the separation of EDM for all the reasons I gave. I would suggest that the guidelines be much more inclusive on the descriptions of anti-competitive effects.
The one thing I would change is the guidelines don't currently connect the examples with a generalizing framework, and I think that's the one addition I would stress making. And I guess to complete my circle of insanity, I'll disagree with Renata that I would keep the emphasis on a related market, and I'm okay with changing the labels, but I think there is value to that.
I've already talked about EDM, so let me just talk about one issue I haven't raised, but which I think Craig did allude to. In Section 5, the unilateral effects portion, there's a set of conditions, 4 conditions are set forth, and then the sentence, mergers for which each of these conditions are met potentially raise significant competitive concerns and often warrant scrutiny. That could be read to suggest that each of the 4 that precede it have to be present. Each one has to be present to warrant scrutiny. I think that's problematic because one of the ones before it is the clause that uses the word de minimis, and I find that confusing. It's not necessary. The legal standard follows it, substantially lessen competition, and I worry that the word de minimis, where the legal standard already exists, would be read as meaning something else, and I worry that something else would mean quantification, and I think that would be inconsistent with the way AT&T was litigated, even the way it was decided, the way we understand non-price harms like innovation and harm to quality. And also, these 4 factors have a profitability test that I'm not sure where it comes from. I'm not sure why the question of profitability is a part of this merger analysis as a separate consideration. But in particular, I don't understand why, if conduct was profitable but becomes more profitable afterwards, that wouldn't be enough to satisfy any inquiry along those lines. And so I am concerned that this reference to each of these conditions and these 2 as among them is something that should be changed.
Yeah, not surprising. I think I'm consistent with that. I would really expand as much as possible the scenarios under which the agencies would find a problem. I would marry the examples, as I said in the beginning, split them down the middle. Here's numbers and facts that show that these are a problem, and here's numbers and facts that show that this is not a problem. And I would certainly, I guess if there's one part of that I would do is the de minimis one. I think that's awfully confusing.
No pressure. But if you have a...
So quickly, I would keep a safe harbor.
Fair enough. Well, thank you all very much. And I think we have a break, but please stay, and thanks for coming.
Thank you. Bob, can I just say, it's a treat to hear you talk about these issues. No, I'm being serious. It's one of the things I miss.